Excuse me.
Okay, Ben, we're ready when you are.
Okay, thanks, Joe. Well, firstly, welcome everyone to our discussion on the likely changes to the employment conditions that we can expect from the current Commonwealth Government. We're going to have a bit of a panel discussion today. The panellists will be myself, Ben Cooper, an Associate Director based in Brisbane, Jamie Patterson, an Associate Director based in Melbourne, and Sarah Spivey, a Principal Consultant based in Perth. So again, welcome to everybody. The agenda that we're going to be working from today is really what we've got up on the screen. I'm going to have a general discussion around the Albanese Labor government and what we think are its prospects in terms of its capacity to affect change, and the Jobs Summit that's commencing on the 1st and carrying through to the 2nd of September. Sarah is then going to lead us in regards to the gender equity section. Jamie will follow through with the wages and bargaining, and then I'm going to follow back around with the job security aspect. I would invite you to share any questions that you have during the presentation or during the discussion with or through the teams. Joe, who is facilitating the back end of this discussion, will be collating those, and we will have a section at the end to discuss those. Okay. So where are we at in regards to the Albanese Labor government? So currently the ALP have 77 seats in the House of Representatives. The Coalition have 58. That leaves 16 crossbenchers. So there's 12 independents, most of them Teals, and 4 Greens. So clearly on the basis of those numbers, it's clear that the ALP will be able to get any legislation that it wants through the House of Representatives. But the construction of the Senate is a very different matter. So in the Senate, the ALP have 26 seats, whereas the Coalition have 32 seats. So clearly the ALP will need the votes of some of the crossbenchers to be able to deliver any legislative change. The breakup of the crossbench is that there's about 18 seats, of which 12 of those are Greens, and then in the remaining minors and independents, there's a further 6, including the Katter Party, One Nation, and the Jackie Lambie Network. So we would obviously see, to get the numbers, the ALP will require 7 crossbench seats. We think that it's highly probable that the ALP will be able to obtain those votes, particularly from the Greens. The Greens election platform aligns with the ALP's in many respects, but probably goes further than the ALP would generally be looking to achieve at the moment. For example, the Greens have flagged that they want to remove the capacity for what they would see as any unsecure employment. So effectively, all jobs would become permanent jobs. Now, we know that that's not particularly practical. I think that the ALP will understand that it's not going to be particularly practical for some enterprises as well, but I think it wants to look to minimise the scope there. And I think we can take some guidance from the way that the ALP and the Greens have worked together in terms of the emissions legislation, which has been passed recently. The Greens have certainly not got everything that they wanted, but unlike their approach back under the previous Rudd Labor government, they've chosen not to try and block the legislation, but to achieve what they can through the process. So that all being said, we think that there's a reasonable basis for the ALP to be able to achieve the legislative process that they're proposing. Sorry, it looks like I've just lost my screen, so I will bring that back up. Apologies for that. All right, so in terms of the ALP, as I said, we suspect, or we think it's highly likely that there will be legislative change that they've been able to achieve. But rather than railroading that process through, they've taken a consultative approach. And in some ways it harks back to the Accord of the 90s, the tripartite grouping of unions, employers and government, but extended that further out to include broader representation from the community. So the Jobs Summit will include everyday Australians that wish to participate. It'll also include representatives from different cultural communities as well. But obviously a significant focus is going to be on achieving a degree of consensus between unions as representatives of employees, employers and government. Now the Treasury has issued a issues paper in advance of the summit occurring, and we think that some of these statistics provide an interesting snapshot of some of the challenges that the nation faces and that the Jobs Summit is particularly going to focus on. So broadly speaking, productivity has dropped significantly since 2004. So that period of 1989 to 2004 was probably the golden age of enterprise bargaining. And since then, there's been a very slow stagnation in enterprise bargaining, and that has been, I suspect, largely driven by the lack of ability to get significant productivity improvements since 2004. And we see that in the next two points, where the proportion of the proportion of employees covered by enterprise agreements has dropped in the last decade from 43% to 35%. And similarly, the amount of agreements, agreement applications as opposed to agreements, so this would include those that were not approved by the Commission as well, has dropped from just over 7,000 to 3,753 in that same sort of time frame. And this, I think, also reflects some of the difficulties that employers have perceived over the last 5 years or so in terms of the difficulty of getting agreements approved through the Commission. The other areas that are going to be of focus are around secure employment. And so the Treasury tells us that currently 23.1% of Australians are employed on a casual basis, and that the significant proportion of those are women. So that's a clear focus area, which Sarah will talk about in a second. But also importantly, in regards to trades and manufacturing in particular, the amount of Australians entering into trades courses, or the amount of Australians completing those trade courses, I should say, has dropped in the last 5 years to 50% of that application rate. So what that tells us is obviously that employees don't see trades as an attractive career as they once did, but also it means that there will be significant scarcity for those skill sets, and we expect that will continue to impact on wage rates and enterprise bargaining, where trades are a significant proportion of the workforce. So the way that the ALP have proposed that the summit will be addressed is that it will cover off 5 key themes. And as you can see on the screen, those are maintaining full employment and growing wages, boosting job security and wages, lifting participation and reducing barriers to employment, delivering high quality labour force through skills and training, and maximising opportunities in the industries in the future. Now, you'll see that there's obviously some alignment with some of the key topic areas that we've chosen to speak about today. We thought we'd just take a moment to have a quick survey to see which of those 5 areas you think as employers are going to have the most impact on your business, and what thanks, Joe. So Joe has just put up a poll for you to complete. So if we could maybe just take a minute, and then we'll see what the results of that are. All right, Joe, have we got enough information there to be able to have a look at those results? Okay, so clearly that skills training piece is a critical juncture for employers at 42%, and that maintaining full employment and growing wages sitting not far behind at 33%. So that aligns largely with what I personally would have thought. I think also that boosting the job security and wages, although you've recorded it there at fairly low at 13% compared to the others, I think that is going to be an area where there will be further investigation required as we move forward. Okay, so Joe, I just asked you to close that screen. So thank you for that. I might turn now to Sarah, and she'll be able to take you through the next part of the presentation.
Thanks, Ben. So the ALP, as part of their pre-election promises, made commitments to support gender equality and address the gender pay gap. So while the plan in some ways provided limited details about some of the specific amendments, it was clear that there's a potential for significant reform in many areas of employment legislation. 2 years on from the Respect at Work report, which was that national inquiry report that commenced in 2019, it's clear that the prevention of and response to sexual harassment and sex discrimination in the workplace will continue to be an important issue for employers. In the issues paper that Ben mentioned before for the upcoming Job Skills Summit, the ALP have said that shaping the future labour market, that all people should be supported to access employment opportunities while feeling safe at work and also being free from workplace discrimination and harassment. And what we've seen also is that safety regulators like Safe Work Australia have also taken a number of steps to make clearer the existing obligations of employers to address sexual harassment and sex discrimination as a psychosocial safety risk now. There's many industries that we've seen in the spotlight for this topic, particularly the WA FIFO mining sector that went through the recent parliamentary inquiry. And importantly with this, we also saw the public release by Rio Tinto of their Everyday Respect report, which was undertaken by former Sex Discrimination Commissioner Elizabeth Broderick. So in terms of what might be some of the specific changes that we might be likely to see, one of the main ones is the introduction of 10 days paid family and domestic violence leave. So currently the National Employment Standards have an entitlement for employees to 5 days unpaid family and domestic violence leave. And the new legislation that the government has just introduced at the end of July, a bill called the Fair Work Amendment Paid Family and Domestic Violence Leave Bill, provides for this 10 days paid leave entitlement, and it will be broader in that it will apply to casual employees. And it's available upfront to employees, meaning at the start of every year, they have these 10 days of paid leave that they can access, and they have that entitlement to 10 days every year. It's also a bit different to other forms of leave in that it's paid at the rate the employee would have earned if they had been working rather than needing to take the leave. And it's not paid at base rates. So in terms of where that change is at, the bill was introduced to Parliament so late July, and it's been sent for an inquiry where there was a 2-week deadline for submissions on the legislation. It's now with an Education and Employment Legislation Committee who will review all the submissions and issue a report by 1st of September. The timing for when the entitlement might come into effect is proposed to be not until February next year. And there's also talk that there would be an additional 6-month transition period for businesses that meet the definition of being small business employers, to give them additional time to make changes to their HR and payroll processes. Some of the other changes that have been talked about by the ALP include giving employees the enforceable right to request a change to hours or other flexible working arrangements for parenting and caring, and also ensuring that flexible work arrangements accommodate unpaid caring work. So this includes for family members with a disability and without employees fearing that they'll be subjected to any form of discrimination. There's also been some talk by the ALP of changes to expanding access to paid parental leave. So this would be to increase support for parents and promote equal parenting. So the goal is, I believe, 26 weeks of paid parental leave at full pay with superannuation funded through both government and employer contributions, and increased eligibility for the paid parental leave to be shared by both partners. Turning to the next types of changes that are being proposed, as I mentioned before, these come on the back of the Respect at Work report. So the Labor government has promised to combat sexual harassment and sex-based discrimination by implementing all 55 recommendations from the Respect at Work report, other than those that are already being put in place by the coalition government when they were still in power. The most important of these, I think, for employers will be the change to an introduction of a positive obligation upon employers to prevent sexual harassment in the workplace. The way that the current legislation, the Sex Discrimination Act, works is that it's very much a reactive process where it entails a complainant raising a formal complaint, whereas this change would pass a positive duty on employers to take reasonable and proportionate measures to eliminate sexual harassment and sex-based discrimination and victimisation in the workplace as much as possible. Another recommendation from the Respect at Work report that might be one for employers to closely consider is a recommendation on a practice note or a guidance or a guideline that identifies best practice approach when on the regulation of non-disclosure settlement agreements arising from sexual harassment claims. So if this was to be implemented, employers would need to reconsider their approach to the settlement of any sexual harassment related claims in the future, and how they might use non-disclosure settlement agreements. Other proposed recommendations include enabling unions as representatives of employees to bring sex discrimination legal action on behalf of complainants, and also increase powers for Australian Human Rights Commission to initiate their own inquiries, also for the Sex Discrimination Commissioner. There's also, as part of the Respect at Work report, the opportunity to establish cost protections for complainants. So at the moment, somebody raises complaint that goes through Australian Human Rights Commission. If they lose that matter, then there could be the risk of hefty costs that complainant has to pay. And there's also there may be inserting a clear prohibition on sexual harassment in the Fair Work Act and a new complaints mechanism. And this could be similar to the current stop bullying orders. I think there've been talk of there being a similar type of complaints process that may be included. The Labor Party or government, as part of the proposed changes, was also committed to addressing gender pay inequity. So the national gender pay gap currently is 13.8%, with women in full-time work earning $255.30 per week less than men. And research has found that this occurs in every industry, even those that are female dominated industries. The gap is even larger for some women in some groups, so those in regional areas or those with disabilities. And as Ben mentioned before, what had come through the issues paper about the significant number of women in casual employment, it's the same in terms of part-time employment as well. So, over the age of 35, it's much more common for women to be, for members of the workforce who are part-time to be women. And so the gender gap is probably actually even more significant than those full-time earnings demonstrate. To address some of these issues, the ALP has advised that it will make gender pay equity an object of the Fair Work Act and will put in place a statutory equal remuneration principle to help guide the Fair Work Commission's review of equal remuneration and work value cases. So it's proposed to set up and fund 2 expert panels within the Fair Work Commission, one for pay equity and one for the care and community sector. And these will operate in a similar way to the current annual wage review expert panels. The purpose of these will be to ensure the frameworks and principles applied by the Commission reflect up-to-date research and knowledge about what works to reduce the gender pay gap. The ALP is also committed to legislating so that large companies will have to report their gender pay gap publicly, and prohibiting pay secrecy clauses in employment contracts, giving employees the right to disclose details of their pay if they want to. And they've also said that they will take action to address the gender pay gap in the Australian Public Service. Next slide, please, Ben. Thank you. So this is obviously a lot of areas of potential change. So what would be some recommendations we might make for employers? It will be, important for companies to remain sort of attuned to any developments in this space, particularly in the changes and bringing in recommendations in the sex discrimination and harassment space. Because if these are implemented, it will require substantial review and potential updates to HR policies, procedures and employment contracts. There's a number of other steps that employers could be taking now as well, just to ensure they're adopting an approach that would be consistent with best practice that is emerging for preventing and addressing sexual harassment and discrimination. So one of these would be sort of making the shift from the current system of the very reactive complaint-driven approach to focusing more on a risk management focus. So assessing sort of the risk of sexual harassment or sex discrimination that could be occurring in the workplace, and taking positive steps to minimise those risk factors or eliminate, if possible, any risk factors that might be present. We've found with many of the clients that we're working with that this is a really key issue and hot topic that their boards and senior executive teams want to address and investigate within their companies. So some of the actions that companies are taking include cultural reviews or engagement surveys to gather information on the experiences of the workforce, and conducting training for employees and leadership teams on safe and respectful workplace behaviours has also been a key focus area. With the changes that are proposed relating to gender pay equity, employers should give some consideration to what the gender pay gap may be in the organisation, how this could be addressed, and there may be a requirement to actually review remuneration for employees if any changes come out of the Fair Work Commission panels for their specific industry or more widely. So that's it for me, and I'll pass over to Jamie.
Thanks, Sarah.
Thanks, Sarah. Thanks, Ben. So good morning, everyone. So when it comes to wages and bargaining, by way of setting the scene, I guess, if we can cast our mind back to 2007, when at the height of the work choices regime, so you had a system that was very heavily focused on an employment relationship that sits at the individual level, a system that pushed the unions out of the employment relationship to the point that there were any collective agreements at the time weren't allowed to have any union clauses, any union dues or union meetings or union delegate reference. So it was called prohibited content. So we saw a system back then that swung quite heavily to the right. Naturally, in 2007, when Kevin Rudd came into power, there was a strong push by the Labor government then and by the union movement to push the pendulum the other way. Let's see some legislation that it was more aligned with employees and was a little bit more union friendly. And of course, that where we ended up was the Fair Work Act and the Fair Work regulations. At the time, there was a very strong, and still is a very strong opinion amongst some areas, particularly within the union movement and the ALP, that the changes to the system didn't go far enough. So now that we've got a new Labor government, there's a strong view that this is now the opportunity to have a look at the system and really push that pendulum further to the left and further in favour of the employees and the unions. Two ways they're going to do that is through wages and through bargaining. So let's have a look at those now. Thanks, Ben. So in the wages side of things, this is information I'm sure a lot of you are aware of. It's information that's happened recently. They increased the minimum wage by 5.2%. We've seen increases to the award rates as well, from anywhere from sort of 4.6% or $40, depending on the award and the weekly rates that was contained in that award. They've indicated they're likely to push for high increases in areas like aged care, so looking sort of for towards 25% as an example. But the message they've sent out there is they're keen to keep pace with inflation. It's obviously a different approach than the coalition government would take when it comes to inflation, but that's what we think is going to happen there. So where it's going to go, it will largely depend on where inflation goes and pressure from industry, but also pressure from the unions. So that's what we've seen so far. The other area that of concern around the wage side of things is wage theft. So over the years, we've seen increased prosecution against organisations and individuals in regards to the theft of wages. We've seen George Calombaris, that some of the big employers, Woolies, Coles, etc. Mapping's worked with a lot of big organisations in their enforceable undertakings with the Ombudsman, but we also work a lot with smaller organisations who come to us and just want to get it right. It's a complex system with the various awards, etc. So smaller organisations just want to get it right. But what we are seeing the Labor government pushing for at the federal level is they're going to push to criminalise wage theft. We've seen it at the state level. They've indicated that any federal laws will work in conjunction with those state laws. And we've seen it in Victoria, Queensland and Western Australia, where, give or take, these figures, we've seen potential fines of up to 198k for individuals, close to 1 million for companies, and potentially in the most serious cases, 10 years in jail. So wage theft is going to be something that they're going to definitely keep a focus on. Thanks, Ben. In the bargaining side of things, so we sort of see 4 areas where they're really going to push to make some changes here. The sector bargaining in some sectors is one area that they've indicated that they want to focus on. So there's a view that we currently have less workforces or large workforces to drive above award conditions in Australia. When you think back about the likes of Toyota, Ford, etc., that have all packed up and left, that bulk of workforces that brought power to the bargaining table, that was able to drive above award conditions, is no longer there. So as a result of that, the ALP and the unions have made it pretty clear that they want to look at multiple same industry employers and bring them all together into sector enterprise agreements. Some of the sectors we're talking about potentially are going to be aged care and childcare. So we might see some, probably will see, I'd say, some sector enterprise agreements in those fields. The representative cohort, so the unions are pretty strong and the ALP is pretty strong, but they want enterprise agreements that are bargained in good faith with the representative cohort. Representative cohort isn't really defined, but so what we'll probably potentially see from the ALP is better definition around that. It could be the likes of a certain percentage of your workforce, a certain number. It might be a certain number from each of the classifications contained within an enterprise agreement. But suffice to say that they're going to be pushing for, to try and stop employers entering into an enterprise agreement that's going to cover a lot of people, but entering into that initially with 2 or 3 employees. So there's going to be a lot of scrutiny on those types of agreements. They may not either A, be approved at all, or they may be approved for an interim period only. So where you might go in with 3 or 4 employees on a 4-year enterprise agreement, they may only approve it for the sort of 6 months or so to give you, the employer, the opportunity to ramp up their workforce and get some more people on board to really bolster up that representative cohort. Termination of agreements. Look, the unions have for a long time made it very clear that they don't like the ability for an employer to reduce employee entitlements down to award conditions by terminating an enterprise agreement. So, that's always been a bargaining chip for employers at the table. It may not necessarily be a bargaining chip that they openly communicate, because it doesn't really set the scene for a good negotiation. But it's always been in the background that the employer can apply to terminate the agreement and put us back on the award. So that's likely to be removed, we think. And the other area with regards to terminating an enterprise agreement is pre-work choice or work choices or zombie agreements. So agreements that were put in place back during the work choices period that are still in operation. The key thing there is that employees under those agreements, who remain under those agreements, only have to be paid to a minimum wage, not to the award. So as you can expect, they're not very popular with the unions or with the ALP. So we expect at a point in time, they'll simply just terminate zombie agreements, and employers will be required to enter into new enterprise agreements under the new system. And we expect to see increased powers of the Fair Work Commission as well, particularly around this bargaining area. We expect to see arbitration on disputes associated with bargaining. The Fair Work legislation is very good at getting the parties together at the table, very good at getting them back to the table when they don't agree, but it's not very good at getting an agreement, because the ultimate agreement sits with the parties to the employment relationship, the employers and the employees. So we're likely to see something there where the Fair Work Commission will be able to arbitrate an outcome or arbitrate on disputes. Thanks, Ben. Ben, you're on mute there.
Sorry about that. Some technical errors at my end, but hopefully that's rectified that. All right, so I'm going to wrap up the last part of the section in terms of job security. And then we're going to focus particularly on these three following areas. So the first one is in regards to casual employment. Now, many of you will remember that through the late, say, 2018, 2019, there was considerable focus placed around casual employment with the federal court decisions in Rosato and Skene. Both of those were against WorkPac, in which case, both cases, the federal court held that the definition of casual employment was related to there being no fixed advanced commitment to work by the employee, by the employer to the employee. And as such, both the employer and the employee had the capacity to reject either, to not offer work or to reject an offer of work made. That position was changed in 2020 when the High Court reconsidered the Rosato decision and ultimately found that the matter was, or an employment status could be determined by reference to the employment contract, and that the behaviour of the parties subsequent to the execution of the contract wasn't relevant. And we saw that the Morrison government changed the Fair Work Act to bring a definition in that was congruent with that High Court finding. Now, what the ALP have indicated is that they intend to bring in an objective test, recognising that, yes, the contract is important because it specifies what the parties have entered into, but acknowledges that through the operation of work, particularly over time, a different type of employment relationship has developed. So largely it will take us back to the pre-High Court position. And obviously that potentially causes significant uncertainty for employers, because we end up back in the situation of not knowing whether somebody is truly a casual or if they're a permanent employee. And obviously if they're later held to be a permanent employee, then there are significant costs associated with that in terms of leave accruals and so forth. The other aspects that the ALP are focusing on particularly is in regards to the limitation of fixed term appointments. Now, the Fair Work Act currently does provide for an employer and employee to enter into either a contract of a specific duration, i.e. a fixed term contract, or a contract for a specific purpose, so a project type contract. As it sits at the moment, there is little guidance on how many contracts an employee could roll over from one to another. There is a full bench decision of the Fair Work Commission called Navitas, which went through and considered the case law as it was at the time, and has determined that the key feature that determined when somebody moved from temporary employment to permanent employment was really when the employee perceived that they had ongoing employment. So in some senses, the proposal by the ALP can provide more certainty to employers in terms of working out whether somebody is temporary or permanent, because likewise, if they're permanent, there are leave accruals that might need to be considered beyond those already provided for permanent fixed term employees. But more importantly, it's the risk of whether somebody can bring an unfair dismissal claim at the end of a contract term because they haven't had the contract rolled over. Now, the ALP is particularly focusing in on areas where it sees that employees are at high risk because of the vulnerable nature of employment, and again, particularly areas where there is high female participation. So those similar to what Jamie was talking about in bargaining, but also Sarah was talking about in terms of some of the gender equity issues. We expect to see a strong focus for these type of changes in the education space, in childcare, in aged care, in nursing, and similar types of professions. There isn't a lot of clarity yet that's been provided by the ALP on how they expect this will work, but there has been a similar model in the UK for some time, where in essence, if you had exceeded 2 years of employment then you were effectively considered to be permanent. And so that will give the employees the capacity to bring an unfair dismissal claim, or similarly, if the contract wasn't renewed at 2 years, then the employee would be eligible for severance payments. Now, obviously, that runs counter to the reason why most employers would use fixed term contracts or fixed project contracts, because they are for a specific purpose. And often we find that the time frame that we're looking at is in the range of, often they are 1 year, but often we'll find that the employer will be looking to have a 3-year or a 5-year contract in place. And clearly that will no longer be possible. And then the third area that we thought was worth mentioning was in regards to gig workers. Now, obviously, with the rise of some of the online platforms, such as Uber or Menu Eats or any of those type of arrangements, a lot of the workers in that space are not classed as employees. They fall into a kind of category which has been referred to as gig workers, but we would probably see them being closer to independent contractors. The proposal is that the Fair Work Commission will have the jurisdiction to set minimum rates of pay in those circumstances for non-employees. And similarly, they will be able to set other terms and conditions like hours of work, penalty rates, and so forth. So the Treasury issues paper that we mentioned before indicates that it's a fairly small percentage of the population that are engaged under those sort of arrangements, around about 250,000. So it's, I say it's small, but it's not inconsequential. And again, a lot of the employees that might be working in that space are likely to be considered vulnerable, either because of their gender or their racial background or some other type of employment concerns. All right. Well, that really concludes the discussion that we were going to have today. Joe, is there any questions that you're able to pass on to us?
Yeah, I've got a couple of questions here. I think the first one here will be for Jamie. It's just about the proposed changes to enterprise bargaining. Will these mean that companies who have chosen to roll over their enterprise agreements over the last few years, but have passed on the Fair Work increase, will they have their agreements cancelled?
Okay, fair question. No, look, it's what I was more talking about is the agreements that were made under the work choices regime, which they commonly refer to as zombie agreements. So those agreements were made and they're still in place, and people are still working on those, and they're the ones they're going to terminate. They don't like them because they were made under the work choices regime. They were tested against the minimum wage, not against an award, and so they see those conditions need to be, or those agreements, or any agreement needs to be tested against the modern awards. With current agreements that have expired, that were made under the Fair Work legislation, they underwent a book test against one of the modern awards. So despite the fact it's been expired, those agreements will still stay in place. Obviously, you need to monitor against any award, underpinning award wage increases, etc., which sounds like whoever asked that question has done. So those won't be terminated. It's the zombie agreements that were made under the work choices legislation.
Thanks, Jamie.
You're welcome.
I have one for Sarah. It's in relation to eliminating sexual harassment. What is a positive duty to eliminate sexual harassment, and what would this require employers to do?
Okay. So yeah, the positive duty comes from that recommendation in the Respect at Work report, sort of providing a change to the way that the Sex Discrimination Act is currently worded. So the positive duty is about employers taking reasonable and proportionate measures to eliminate sexual harassment or sex discrimination in the workplace as far as possible. So determining what measures are reasonable and proportionate, the Act will prescribe some various factors that should be considered. The positive measures are likely to be to differ depending on the circumstances of the organisation. So things like the size of the organisation, the composition or makeup of the workforce, and the costs perhaps that would be involved in implementing any of those positive measures. But the positive duty, it's important to probably make the point that it doesn't mean that doesn't require the employer to prove that such conduct would be impossible in their workplace, but just rather that they've taken proactive or preventative steps to address to reduce the likelihood of incidents of that kind of conduct occurring. I hope that, yeah.
Thanks, Sarah. Ben, I've got one for you. With all the changes you've discussed today, are there any changes that will likely apply to independent contractors?
Yeah, thanks, Joe. That's a good question. The short answer is yes, we think there will be. So the current situation is that about back in the early 2000s, the High Court determined that you didn't look at specifically the contractual relationship between the parties. You actually looked at the true nature of the relationship. And as such, the court could infer that there was an employment relationship between the employer and the employee, who were otherwise acting as sort of principal and independent contractor. That position was overturned last year, where the High Court took a similar approach to casuals, or what it found in the Rosado casual decision. And it said that the primacy for determining the true nature of the relationship was the contract. And we've seen that now followed in a couple of decisions of the Fair Work Commission. There's a recent full bench decision from Deliveroo where the Commission has rejected a person's application for unfair dismissal on the basis that they'd entered into a contract which was for an independent contractor agreement. Similarly to casuals, the ALP are likely to take us back to that pre-High Court decision, and there will be an objective test, and it will be an assessment of what is the true nature of the relationship between the parties, taking into account the kind of the tests that we're all familiar with. So control, provision of equipment, capacity, or kind of the requirement to rectify errors and so forth. Essentially, is the person running their own business, or are they an extension of the employer's business? So
Thanks,
back
Ben.
to the future.
I think I've just got one final question at the moment for Jamie, again in relation to bargaining. Do we think that the new government will introduce any bargaining fees?
Yeah, excellent question. Bargaining fee. So by way of context, a bargaining fee is a fee payable by a non-union member to a union who negotiates an enterprise agreement with the employer on behalf of the full workforce. It's a long-held position by unions that they should be getting a fee from non-members who are in their eyes are benefiting from the terms and conditions that the union fights for at the table. Unions eloquently refer to them as freeloaders. So it's been something the unions have been pushing for years. And again, if you cast your mind back to 2009, when Fair Work legislation came in play, the Gillard-Rudd government left this alone. They saw that there was a view that it encroached too closely on the freedom of association, and also on the right of an employer or an industrial organisation to force people to spend their money or allocate their funds, their pay onto anything. They just don't have a right to ask them to do it. So back then it was left alone. I know the unions are going to push it at the summit. I know the ACTU and Unions New South Wales are going to push it. The question is, do I think it's going to get in? I'm going to go on record here and say no, simply because it's a little bit complex when it comes to protecting that the integrity of the freedom of association, the freedom of people to join a union or not join a union. At the negotiation table, if the union want to represent more people, then they need to be getting more members. So I don't think the bargaining fees will get through, but it's certainly going to be on the table for the ALP to consider and respond to.
Thanks, Jamie. I actually have another question on a similar note in relation to union membership. Is the AWU proposal to default migrants to union membership as part of their employment conditions a serious reality that could come from the summit?
Look, I'm going to go on record again and say no, I don't think so, because at the very core of our industrial framework is the freedom of association. It's the freedom of an individual to join or not join a union, the freedom to organise and bargain collectively or not. The not can be difficult when you're in a workforce, but I don't think that will get through. Ben, did you have a view on that at all?
Yeah, I agree with you, Jamie. I think that probably goes even further than the bargaining fees, because there's a direct correlation between the employment and union membership, and that would fall foul of the freedom of association provisions, which are contained in our legislation, but more importantly are United Nations conventions to which we've signed up. So I can't realistically see how that can get through. The other aspect of that, I guess, also is that it's probably only pertinent to some classes of migration. So we know through our own migration operations that people come in to Australia to meet a wide range of skills shortages, whether those are technical or professional. So I can't see how there can be some sort of compulsion to join any union, but more particularly one union. All right,
Thanks.
Joe, is there anything else? No?
No, that was all the questions I have at the moment.
All right. Well, thank you everyone for your time. That really wraps up the presentation that we've got. Sorry, I'm just having, again, some technical difficulties. We would like to offer the opportunity that if there are any subsequent questions, if you communicate those through to us, we'll certainly try and respond to those. There will be some links that come out after the presentation, both to those questions that we've addressed and some other blog articles that we've either prepared or about to release that cover off on some of these topics as well. So thanks again. We appreciate your time. We appreciate that it's valuable, and hopefully you've received something of value from today. All right. Thank you very much.
Thanks, everyone.
Thanks, team.